attend this webinar. I really appreciate the opportunity to give you this briefing on bid protests. Bid protests are, seemingly, a fairly straightforward process, you would think. Do you feel that there's been a problem with the procurement, and you should be able to complain fairly easily, you would think, to get a remedy for your situation. But having done this for a number of years, I can tell you it is a pretty complex process with a bunch of nuances. So the intent of this briefing isn't to give you the knowledge to to be able to bring a bid protest on your own, although you'll have a better understanding of it. The purpose is to kind of give you an opportunity to know the process so that you can be able to identify issues and to proactively, when you're building your procurements or your proposals or bids, put together a proposal or bid that prevents any need for bid protests, if at all possible. So if you can go to the next slide, Curtis, I'd appreciate it. So I'm not sure the experience level of the audience that is attending the briefing. So I've put together kind of somewhat of the basics, but also expanded on that so that people that have a little more experience have maybe experienced a situation where they wondered if they should have protested and felt that they were wronged in the process. That you'd have a better understanding at that level of what you might have done in that circumstance and what you might do in the future if something of that nature comes up. So I'm not going to be providing a detailed schematic on the whole bid protest process because, like I said, it is very complex and there's a lot of minutiae and detail that we would need to get into to cover the whole process. At the outset, we're going to look at the proposal process because the proposal process and the acquisition type really informs the mechanisms and the ability to protest, to file a bid protest. And so a basic understanding of the different acquisition mechanisms is going to allow you to understand what ability you have to protest, because in certain circumstances, there's very limited ability to file a bid protest. And those acquisition vehicles are structured so that the ability to file a bid protest is limited, and you should understand that when you're going about preparing a proposal. The bottom line is the best prevention for bid protest is to prepare a flawless proposal. And I'm sure everybody attending this webinar, that's your intent to do that. And I'll try to give some tips on things that I've seen that could help you in putting together your proposal, whether you're using a outsourced proposal developer, for your oversight of that process, or if you're preparing your own proposals internally. I'm not sure what the audience is using as far as proposal developments, if you're doing it yourself, or if you're using outsourced services for that, or a combination of that. But I'm going to try and cover that so you have a better understanding, so you can manage the people that are providing the outsourced services, or if you're preparing the proposal yourself. If you could, next slide, Curtis. So the bid protest process is going to be different depending on as I said, the different procurement types. And I'm going to walk through the major procurement types. And there's nuances within each of these, but just to cover the generalities of each procurement type. So if you look at the first one, competitive negotiation, FAR Part 15, in the FAR, I assume you understand, is the Federal Acquisition Regulation. The DFAR is the Defense Federal Acquisition Regulation. But the FAR Part 15 is the most complex, and what you would think about as normal, complex government bid or proposal process. You have various factors, an evaluation plan that determine award, and the evaluation factors and award plan are contained within the request for proposals. It has a formal evaluation plan established. They'll establish a competitive range, hold discussions with the offerors, and they do a best and final offer. And that type of procurement is one that is readily protestable if necessary. It's a complex process for the government to undertake, and in that undertaking that process, there can be a lot of areas where they might make mistakes in that process, and there are opportunities for bid protests in those. FAR Part 15 procurements are utilized normally in larger, more complex procurements because of the complexity in putting together the FAR Part 15 procurement. The next procurement type of GSA schedule contracting, it's under the Federal Acquisition Regulations, Subpart 8. And these are you've, I'm sure, heard of GSA schedule contracts. And if you don't already, if you're a company, one of the things you want to try and obtain is a GSA schedule contract in the area that you're operating. And the GSA schedule contract, a couple of those that are common are the MOBIS contract, which is, the program management support type of work, and other more, program support type services. And then Schedule 70, the IT contract. And what that entails is GSA sets up schedule contracts with each contractor where they have best pricing and that from the contractors already established. And so federal agencies can go directly to the GSA and do a procurement through the GSA schedule contract. The procedures with a GSA schedule contract are streamlined because they've already set up the pricing and gone through the process with the contractors. So the bid protests formality, or the proposal formalities, are minimized with a GSA schedule contract. And therefore, although there's still a large ability to protest on a GSA schedule contract, it is not as susceptible to protest as a FAR Part 15 procurement. Because they want us the informality with respect to the GSA schedule contract. Agencies want to use that because of the informality, and it decreases the burden on them to put together these complex FAR Part 15 procurements. The next one to talk about is a commercial item acquisition. And commercial item means that these are items that are readily obtainable in the commercial market. And the reason that the government set up this process is that they didn't want to go through a cumbersome process, FAR Part 15 acquisition. If it's something that you could see in a catalog or buy yourself, why should we go through this Part 15 process where you got to establish a formal evaluation plan if we can do a fairly simple process and procure a commercial item out of a catalog? So they set, although it's supposed to be like a commercial, market procurement process, it still is, with respect to comparing it to the private sector, it's still rather formal. So there are opportunities to protest, but again, because it's a commercial item, the government has established streamlined procedures. So it makes it easier for the government to procure under the commercial items FAR Part 12, and the process for protesting under FAR Part 12 is probably similar to GSA contract. There's still ability to protest. The cumbersome formality and intricacies of the FAR Part 15 aren't there. So there's not as many ways that the government can trip themselves up on a commercial FAR Part 12 acquisition. The fourth one we have listed is the simplified acquisition. The simplified acquisition threshold was increased recently to $250,000 in most cases. This is a very informal process compared to the ones we've mentioned already. As you can see, it encourages accepting oral quotes versus written quotes, prefers comparing quoted prices versus conducting negotiations, and provides streamlined clauses to support the award document. So this is the type of contract where the contracting officer could reach out to vendors, and need to have at least 3 vendors that they get quotes from, and they can make an award directly to those individuals. So in those simplified FAR Part 13 acquisitions, the ability to protest is minimized because the procedures are so informal. And there's also a micro purchase threshold, which is very low, $3,500, where they can just make a purchase directly from a company. And again, there's no limited ability to protest something like that unless there was some impropriety with the purchase. Sealed bidding is what you would see typically in a construction contract, FAR Part 14, where companies submit sealed bids to the government by a particular date and time. And the government, as long as the bid is responsive and meets all the technical requirements, they award to the lowest bidder. So in those circumstances, your ability to protest would be that the government faultily reviewed the bid for technical compliance, or misevaluated the price. So those are the types of protests that you could file with a sealed bid. The final area I wanted to talk about is, as far as acquisition type, is task and delivery order contracts, or IDIQ contracts. And these are under FAR Part 16. These are very common in the government, and the ability to protest those is very small. And you've probably seen these, for example, in the Department of Homeland Security for veteran and service-disabled veteran companies. They've established a contract that's called PACS, and PACS is an IDIQ contract. So the government goes through the process of establishing this IDIQ contract with selected companies, and in that, after that process is completed, it's, in the process, thousands of companies have applied to get on the PACS contract when they're going through the procurement process. Probably 25 companies get award of the actual contract. And then DHS as an agency is encouraged, if they're going to procure to a service disabled or veteran company, to procure directly from the PACS contract rather than soliciting outside of DHS. So being able to have a vehicle, one of the IDIQ holders under the PACS contract, is a great advantage, because DHS, in most cases, if they're going to procure from a service disabled veteran or veteran company, are going to utilize the PACS contract if it fits within the scope of the PACS contract. So your ability to protest an award under the PACS contract, if you're outside of it, is very minimal. If you're on the PACS contract, they compete among PACS contract holders. But if you're a PACS contract holder that's not competed but didn't get award, your ability to protest the award is limited. So it's a great advantage to the government. They don't have to worry about bid protests once an IDIQ contract is awarded. So just with that general overview, you can see that based on the type of procurement, it's pretty complex as to whether, your ability to protest. So say, for example, you weren't on an IDIQ contract and you wanted to submit a bid protest, there would be virtually no opportunity to do that. So just this basic understanding of what type of procurement you're dealing with is very helpful for you in determining your rights for a bid protest. Next slide, please. So some tips to avoid having to get into the whole protest process, and these are kind of simplistic, but things that you really need to keep in mind. As the government reviews your proposal, they're going to go through a very detailed technical review at the outset of your proposal, and things that are going to get you bumped right off are the technical requirements that they put in the solicitation. So it's incumbent upon you, even if you have an outsourced provider doing your proposal, to go through the RFP, the solicitation in detail, and make sure you come up with a checklist or matrix to ensure your proposal complies with everything that the government requires. It's in the government's interest, and it's in your interest to make sure that you've met those requirements. In some instances, the government, if you fail to meet one of these, they can't waive it. Even if the government thinks you have a great proposal, if you don't meet one of these specific things, they can't waive it, because it would be protestable by somebody else. So in order to help the government and help yourself, these basic things should be reviewed and accounted for in your proposal. Page count seems simplistic, but if you're going to go over the page count, parts of your proposal at a minimum could be excluded from consideration. So the government wants your full proposal. Make sure you meet the page count and don't try and play tricks on the fonts and those sorts of things. Make sure that all the required items and documents are included. If there's a requirement to include your certifications, your service disabled veteran or veteran certification in the proposal, even though you've been certified by the SBA and it's in SAM. If the government wants you to include that document in the proposal, you have to include it. If you don't include it, they're likely to exclude you from award. And in that case, if they did try to award to you, it's highly protestable. You want to respond to all the elements. So if you have the price, technical, management, all the different subcomponents of those, and make sure that your proposal addresses each of those areas, because failure to address each of those areas and respond specifically to what the government wants is going to make you less likely to receive award. Make sure your past performance questionnaires are completed and returned. Some of them, many RFPs require them to have your government person return the past performance questionnaires by the time of the proposal is due. So to get your government person to get those in, you want to get them to them as soon as possible so that you can meet the requirements of the RFP. So I would suggest that, even if you have a proposal company doing your proposal, that you prepare a proposal matrix that sets out you go through the RFP in detail, and you set out all the requirements in the RFP so that you can go through that checklist and make sure you have everything covered. And one key thing you want to make sure is that you submit your proposal on time. There's no leeway for the government to waive the submission of a timely proposal. And the thing I want to emphasize with that is that, most proposals these days are submitted by email, and there's a byte limit or size limit on the proposal that can go in, and it's on the contractor to make sure that the proposal is submitted to the government. So if you work on your proposal to a minute before the proposal's due and you submit it and it's bumped back to you and doesn't get to the government in time, you're untimely. It does the effort to get it in a minute early. Doesn't matter. It has to be to the government by then. So I would say make sure you get everything ready well in advance so that you can jump through these IT hoops. Like, for example, this conference, we were on a half an hour before and we had technical difficulties. If we had done it right before, we wouldn't have been timely. So, just word to the wise, make sure that, and I've been there where submitting a proposal, putting things together at the last minute, and you're trying to get it together, but try and avoid that if at all possible. Like I said, read and follow the solicitation, the FAR and the agency rules. Most of those should be contained in the solicitation so they're readily available to you or incorporated by reference. Make sure you understand those and you're complying with those and submitting your proposal so that you cannot be bumped on a technical requirement. Next slide, please. So what is a protest? So a protest is a written objection submitted by an interested party to the terms of the solicitation. It could be pre-award. So things might come up before the government awards a contract that you'll need to solicit, and we'll go over those in more detail later in the briefing. Or to the procurement process itself, that can be pre-award, where you're disadvantaged somehow in the procurement process and you feel that it's not fair and needs to be protested. You could be excluded from the competition, pre or post award, and those are protestable. You can protest the competitor's eligibility of whether or not they should be eligible to submit a proposal. You can protest the award or proposed award of a contract post-award, and that's the most common, where you think that somebody's awarded a contract and you protest their receipt of the contract because you've submitted a bid. And one of the things to keep in mind is that you have to be an interested party in the procurement. So as to be an interested party, you have to have had a likelihood of being awarded the contract. So if you were, like I said, if you didn't timely submit your proposal, you don't have standing to file a bid protest. So you would be out of luck. Next slide. What may be protested? So let's kind of go through some of the things that you might come across that you'd want to protest. Challenge to a sole source award or non-competitive acquisition. So for example, as you know, probably in reviewing opportunities on SAM, you'll see announcements from contracting officers of sole source awards to companies. And in certain circumstances, you may find that the work that's being sole sourced is work that you could perform and should be have the opportunity to try and perform. So when you see that sole source announcement, you have 10 days from when you see that sole source announcement to protest the sole source announcement so that you can be participate in that acquisition. Um, it's the government has a burden to show that the contract should be set aside sole source, and it's kind of a higher burden. So if you can establish that you are capable of doing that work and should have had the opportunity to do it, it's likely that you'd be able to successfully protest a sole source award. The government, normally does that when it's the acquisition is under urgent and compelling reasons, or there's a reason that because of proprietary software, things of that nature, that the acquisition should be sole source. You can challenge the decision not to set aside a contract for your particular social status. So, for example, here would be service disabled veteran or veteran contract. If the government say does an open bid and you think it should be set aside, you can submit a protest and stating that the government should have set aside the contract for service disabled veteran or veteran contractors. And I'll cover this a little bit more in detail, but in the VA, and you hopefully know this, that the veteran and service disabled veterans have first priority as far as procurement. The government has to look to veteran and service disabled veteran contractors and solicit between them before they can go to other outside sources. And there's a notable decision that was issued a few years ago, the Kingdomware decision, where the Supreme Court ruled that the government had to procure from veteran and service disabled veteran companies versus going to the GSA schedules, because the VA at that time had said the GSA schedule is different. We can go to the GSA schedule because it's a different type of acquisition, as we discussed. We don't have to. This is an open or competition. We don't need to just solicit from veteran or service disabled veterans. And the Supreme Court said, no, the statute's clear. You need to solicit from veteran and service disabled veteran contractors. So in that circumstance, the things you should keep in mind when you're going through SAM and looking at opportunities, if you see an acquisition that's open and should be competed between service disabled veteran companies or veteran companies, that's the point where you should protest and ask that the competition be open. One thing to keep in mind is that the government does market research to determine whether or not there are two or more veteran companies that can do that particular work, and their market research is assisted if you see, say, a sources sought announcement for that work prior, and you say at that time you could perform the work. That informs the government's market research. So it is kind of cumbersome and time consuming to respond to sources sought, but that gives you the ammunition if you send that to the government during the sources sought stage to say that your company is able to participate and fulfill that work. The government has a more difficult burden to say that there weren't two or more veteran companies that could perform that work. Next type of protest, challenges to the terms of the solicitation. Things you would look at there would be, brand name product solicitation. They want a particular type of product, and there's really no need that they should have limit to that particular product, because there are equivalent products out there that would perform the same function, things of that nature. Or the solicitation is ambiguous or unclear in its terms. You want to clear that up as soon as possible in the bid protest process. Challenge to the acceptance or rejection of your bid or proposal. And these are the the preeminent thing that people think about when they think of bid protests. And you get to notice that your bid isn't accepted and somebody else isn't accepted. And you want the opportunity to go after that proposal. Challenges to the agency evaluation or award, just a kind of a listing. I don't want to go through each one. Past performance, technical requirements, management, cost or price, best value trade-off, responsibility determinations, conflicts of interest. One of the things, to keep in mind that there's a common area, and it may not, depending on how large your company is, may not be a problem for you. But if you're in the process, if your company is prepared as a program support or program management, you're supporting the government in preparing technical specifications, you are going to be excluded from bidding on work, and it seems intuitive, bidding on work that is being solicited for those technical specifications. And it seems like common sense, but it's surprisingly occurs more than you would think, where companies seem to think that three people are preparing the technical proposals, the rest of the company can bid on the acquisition that occurs based on those technical specifications, and that's not going to be acceptable and something that will be protested. Next slide. What risk of protesting, and this is a common area of angst for contractors, is that they want to protest and they feel they've been wronged, but they're wondering about how am I going to impact my company over the long term when I protest. Government contractors are professionals. They understand that you need to protest in circumstances, and that they make mistakes, but at the same time, it can damage relationships depending on the nature of the protest and how things occur. You're going to incur legal costs if you go the route of hiring an attorney for it, and your company time. It's time intensive. It's a fast process when we look at the timeline. So during that timeline, you're going to be spending a number of hours working on the protest. So those factors are things that you should consider when determining whether or not you want to protest. Next slide. Do I need to win a protest to get relief? And probably, if you haven't been involved in a bid protest, it might be surprising that the bulk of bid protests aren't, things that go to decision and things that, somebody else is awarded a contract. It's very uncommon that the decider would say, another company should be awarded a contract. Normally, there's some type of corrective action, and that's a big term in bid protests. So the protest went to the GAO. They would say that in many circumstances they felt that there was a problem, but the government should go back and correct it based on the limited guidance the GAO gives, and they give broad discretion to the government to go what they can do to go back and correct it. That could be like anything from reevaluating the proposals, making just a minor technical change, or they could cancel the solicitation, amend the solicitation, and ask for proposals again, conduct additional discussions or clarifications and get additional proposals. And so there's a wide range of remedies that can be afforded in the bid protest context, and a lot of those don't entail awarding directly to the protester. A lot of them most of them are just corrections that the government needs to make to the process. It's possible that the error was such that the protester could be given award after in the end of the process, but it's not what's going to happen immediately, most likely, and it's going to take some time for that to happen. Next slide. So protest form. So there's three main forms for protests that you would be involved with. The first is the agency filing a protest directly with the agency. That's the simple and the easiest methodology. The solicitation will have the methodology for you to file the agency protest, and you'll file a written protest with the agency, and the agency decides. And you may ask, why? What benefit would it be to file an agency protest if I've already gone through the protest with the procurement process with the agency? What difference will that make? There's a few reasons that the agency protest could be helpful to you. Number one, the agency is likely to have different individuals involved reviewing the agency protest and making a decision whether or not um, corrective action should be taken. Second, the acquisition process is very detailed and takes time, and it's an intensive process. And mistakes can be made that the agency overlooks, and if you can bring it to their attention through the agency bid protest process, and they can correct it that way in the least expensive and simplest manner, that's probably what you want to do. So there needs to be an evaluation at that point that you're going to file a protest, whether it would be advisable to just protest to the agency and let them take corrective action. The Government Accountability Office, GAO, is the most common what you think about for bid protests. It's a written protest filed with the GAO. I'm not going to get into the details of the timeline, but just generally know that a protest must be filed within 10 days of when you knew or should have known of the protest. So depends on the procurement method and whether there's a required debriefing. So the briefing gets into complexity as to the type of acquisition, whether it's a required debriefing. So just keep in mind that the timeline is very short if you're going to file with a GAO. So if you think you've been wrong, it's almost immediate that you need to contact somebody, an attorney, to determine whether or not you should file a bid protest, because waiting and mulling it over is really limiting your ability to file an effective bid protest. You need counsel or advice as soon as possible, or you make your own decision as soon as you can if you're going to file with the GAO. The GAO is, if you file a protest with the GAO after award of a contract, the government can stay the award of the contract if it's requested in the protest, or the government is mandated to stay the award if it's requested in the bid protest. And that's a big advantage of the Government Accountability Office, as opposed to the next one we'll talk about, the Court of Federal Claims. If there was not an automatic stay, the government could just proceed with the contract, and the bid protest might be at that point overcome by events if they are able to award and proceed with a contract. So the automatic stay is a huge advantage to have with the Government Accountability Office as opposed to the other protest mechanisms. And the third mechanism is the U.S. Court of Federal Claims. So this is federal court, very litigation intensive, and very difficult for a company on its own to protest at the Court of Federal Claims. You'd have to be a pro se attorney, act as a pro se individual rather than attorney before the Court of Federal Claims. The rules of discovery, the federal rules of evidence, and things of that nature. So say you blew the GAO 10-day timeline, you do have 1 year under the COFC to file a complaint. But it's going to be the most costly and complex methods to litigate your bid protest. There's no automatic stay at COFC. Must be litigated. You have to litigate a TRO, which basically means you have to show there's irreparable harm in not granting the TRO, and you have a likelihood of success on the merits. And even the TRO hearing itself is very intensive and costly to utilize. So given that with respect to the Court of Federal Claims, when would you use the Court of Federal Claims? Well, if you blew the timeline, you may want to consider it. And if it's type of protest where the GAO is, say, settled in its decision about how something should handle, and the Court of Federal Claims has not made a determination on that particular area, it might be advisable to take it to the Court of Federal Claims. So you have a new body making a decision on something that you think is justifiable. So it gives you a different forum from the GAO that might give you a different decision. just kind of a general idea that the sustained rate at the GAO for, the protest is sustained by formal decision is about 15%. That doesn't account for the corrective action, things that would be done by corrective action before a decision is issued. So there is a significant amount of activity that gives protesters new opportunities. Not, like I said, not necessarily award. It gives you new opportunities to potentially get an award through corrective action or decision of the GAO. Next slide. We kind of covered most of these, but the distinction here is the pre-award protest. So, and I'll kind of cover a few examples. Pre-award protests are the solicitation process up until the time the proposals are due. These are called pre-award protests. And when it's a pre-award protest, the 10-day timeline doesn't apply. You have to submit your protest before proposals are due. And things you would think about in this proposal: unduly restrictive competition, organizational conflicts of interest you're aware of, Procurement Integrity Act violations, patently ambiguous contract clauses, things like that should be protested before submission of proposal. So just to give an example, you plan to submit a proposal to build a building, and the concrete specifications are ambiguous. What do you do in that circumstance in order to prepare yourself to submit a proposal? Well, the first thing you want to do is obviously submit a question and try and get an answer from the government as to, do you see this ambiguity? How should we handle it? And the government may or may not resolve your question with regard to the ambiguity. If you do not think it's sufficiently resolved, you need to file a bid protest before proposals are due. And use the same methodologies that you would for a protest after award, that you go to agency protest, GAO press, or Court of Federal Claims. It's basically the same process, but the timing is before proposals are due. And if, say, it's an ambiguous specification, it's called patently ambiguous, it's something anyone, if they read it, would understand that it was ambiguous, that has to be protested before award. Otherwise, it's you can't protest that issue after the fact. So there's many things that you need to raise, those things that you can identify pre-award that should be raised at that time before proposals are due. Another example, say you have a CBP acquisition for helmets for tactical equipment, and the solicitation calls for Bell helmets. Is that protestable? Most likely, yes. If there's no reason that the Bell specifications are different or proprietary to Bell that the CBP wants, you could protest that they've asked for a brand called brand name product, because they can put the salient specifications in the solicitation so that other companies can participate, and you can use other like Riddell helmets. It could be used instead of Bell helmets for the solicitation. So you submit a question and say it appears that you have a brand name specification in here for Bell helmets. We are aware and would want to use other companies like Riddell. Can you put the salient specifications in the procurement rather than the brand name? And the government, it's somewhat uncommon for the government to ask for particular brand names because they understand this issue with bid protests. So it's likely the government, if they hadn't identified it, would correct it, or they'll explain why Bell helmets are necessary for this procurement. And if you think their reasoning is justified, then you can decide not to protest. But if you don't think it's justified, then you can file a bid protest, and the agency protest or the GAO or COFC will make a determination. Another big pre-award protest area for VA and service able veteran contractors is the set-aside decision, like we talked about. So you are the number one and number two priority for VA procurements. And if there's a solicitation that you feel you can participate in, and do you think there would be two or more companies that could participate in and provide that service to the VA, then it's a protestable before award. And I think the VA would probably so the question would be presented to the contracting office so that they can evaluate that themselves before a protest is filed, so that you provide the information and evidence to the contracting officer and say, I'm aware, and you can determine from your market research that there are two or more companies. Please, we'd ask that you set this aside for veteran or service disabled companies, and then if they do, then you would be able to submit your proposal in that set aside competition versus the open competition. And if they don't, and you think it's unjustified, you can raise that protest to the agency or the other protest mechanisms. Again, these pre-award protests, the set aside has to be done before award. You can't be afraid to submit the question or the protest before award, because you're going to be somehow edged out of the competition because you asked the question, because you're not going to be able to submit it after award. It's going to be waived at that point. Next slide. A distinction to keep in mind that bid protests that we've talked about in size and status protests are different mechanisms. So they're filed in different places. So for a size and status protest, they're filed directly with the contracting office, and then it's forwarded to the appropriate SBA office. And the SBA basically handles the investigation and receipt of information from the parties. It's not so much an adversarial process as the bid protest process is. The SBA basically acts as kind of an investigator and determines whether there's a valid size and status protest. So that's kind of understanding that it has to be filed within 5 days of notice of intent to award the contract to a small business. So there's another timeline you need to be aware of. So if you're aware that a company is either affiliated or otherwise doesn't fit the size or status for that's the set aside, the mechanism is this process through the contracting officer and the SBA. It's not through the GAO or the Court of Federal Claims. Next slide. As we talked about, the GAO, the timeline depends on the form and the timing of the debriefing, if any, versus the contracting officer and SBA process for the size and status protest. With the GAO protest, the awardee can intervene in the bid protest. So the protester protests to the GAO complaining about solicitation or award, and the intervener gets notified by the contracting officer that they were potentially awarded the contract, but there's been a protest, and at that point, the potential awardee that was going to get the contract can intervene in the protest so that they can support the government in their decision to sustain the award and not have to take any corrective action. The GAO is an adversarial process. We have attorneys between the protester, the government, and the intervener, and it can be pro se, depending if you feel that it's a type of protest that you can handle on your own. But it's most common to have attorneys involved. And the GAO acts as a judge. It's an attorney that performs the work for the GAO as a decision maker in the case. It's one attorney, but their decisions are reviewed internally with GAO to ensure consistency within the agency. Next slide. That's the extent of the slides I had. I had a few scenarios I wanted to run through with you, just to kind of give you kind of a walk flow of the process by example. So we kind of talked through a lot of the pre-award ones. So I'd give you a couple other ones on the post-award. So let's give an example. You're incumbent contractor and you lose the award to a higher price company. How do you protest that? And so in this example, I just kind of want to highlight the difficulty in certain circumstances in preparing a protest. So you would think that it's obvious on its face that you're the lower priced, they're higher priced, and it's a best value procurement. But even though it's best value, which means that the government can award to a higher price as long as the value they're getting and the underlying proposal is justifies the higher price. So you would think that, hey, I'm lower price. All I got to do is protest to the GAO and say, hey, I'm lower price, they're higher price. You should be able to either get the GAO to take corrective action or either get access to the documents to find out what went wrong. But that's the thing, kind of nuance I want you to understand with the GAO or any bid protest process. With the GAO process, you do not get access to documents unless it's a basis for your protest. And the initial protest that you file can't be speculative, is the wording the GAO uses. So you can't just say, I think something's wrong here. We need to look at this more. The GAO wants specifics as to what went wrong. And it's difficult, lots of times if you're on the outside to come up with those specifics, so you got to kind of keep your eyes open and attuned to what's going on so that if you need to file a protest, you kind of have some ammunition to get through that initial threshold of not being speculative in your protest. So that could be, if you look at the awardee's website and they don't have any experience in the particular work that is being solicited, that could be the non-speculative basis or objective information that they're higher priced and had no experience in this work. So that could be your leg in. And once you get your leg in, you have some ability to get access to documents. And once you get access to those documents, you can come up with other other reasons that the solicitation should be protested. So say you get a copy of the award documents, you can determine that there were errors in the award decision that need to be corrected. They gave you a lower ranking on management that was unjustified. There was no justification for it. You were exactly the same in management, so that was not justified. But until you get access to those documents, you cannot make that argument. But you have to get through that initial speculation part of the equation. And then the other one I kind of wanted to last example before we'll see if you have any questions is exclusion from the competitive range. So pre-award, you can be excluded from the competitive range, which basically means they haven't made an award decision yet, but I don't want to say this, but your proposal was not competitive, so bad that they're not going to include you in the competitive range to make an award decision. So if you're excluded from the competitive range, you have to protest at that time. And there was a case, basically, you can request a debriefing. So the briefing is one mechanism for you to get that information for you to be able to get over that speculative threshold. So the government gives you information, and based on that, you can make a determination or build your case for the protest grounds that aren't speculative. But with exclusion from the competitive range, the government can give you that debriefing, but they can also ask if you want to defer it till after award so that you have a better understanding of what happened. But the problem is if you defer it to after award, you're going to be untimely with your bid protest. So you basically have to take your bid protest pre-award and file your protest after that debriefing. And the debriefings get to another aspect with respect to the acquisition type, because with FAR Part 15, that's the competitive negotiations, debriefings are required. So you can ask for a debriefing, they're required to give you a debriefing, and then your protest timeline begins after that required debriefing. But in FAR Part 13, the debriefing is not required. So if you wait for your debriefing and they give you a debriefing at the 12th day, you're going to be untimely. So that's, kind of just wanted to give you an idea of, with respect to the timelines, how based on the acquisition type and what the government does in response to requests for debriefing, it really changes the timeline and can leave you out of luck. Like I said, there was a recent decision where somebody got excluded from the competitive range. The government gave them the opportunity for debriefing or to defer debriefing till after award. The contractor didn't realizing deferring till after award was going to exclude their ability to protest. They thought they still had that timeline, 10 days from the debriefing to file the protest, but the GAO held that no, they had to get their debriefing and file within the pre-award 10-day timeline, so they could not file a protest after award. So I think that's all I wanted to cover. I don't know if we had any questions. I wasn't paying attention to the chat. I don't know if anybody had any questions or areas that you might have concerns about. But I'll just say that I'm a veteran. I support veteran companies, and I'm glad to, if somebody want to reach out, I can take a few minutes to with any questions you have individually, by email or phone. I can't spend large amounts of time, but I'm glad to help a veteran. And sometimes it's just it's not you want to protest, you just want an idea of, just somebody to bounce an idea off, not necessarily on a protest, but a proposal or things you're confused about in the acquisition process. I'm glad to do that.
Hey, Pat, we do have a few questions.
Okay.
I know we're not going to get to everybody's question before the end of this webinar. As I stated at the beginning, we will respond to your questions and send you an email with your response after this webinar is complete. So here's the first question. If you hold a GSA for unrelated services that you are bidding on, is there a cause for a protest from competitors or the bid that have the correct GSA?
I'm not sure I understand that one too well. It might be best to take that one. If he wants to contact me directly, I can help him with that, because it's kind of hard to go back and forth, because I'm not following the process he's laying out there. I'm sure I can have to go a little back and forth, but probably takes a little too much time.
Sorry, Victor, if you could resubmit your question, who asked that question, your response, please resubmit your question. Thank you. How would a company protest if the sole source award was not posted in SAM for the public to see, or if it was posted somewhere that was not part of the solicitation?
Well, so the sole source award is not a part of the solicitation. So if you're in SAM, you'll see, that's a specific, announcement within SAM. It's sole source decision, and the government, the FAR requires the government to post the sole source awards, so that for the very reason that they want transparency in the government doing that. So if they didn't post it, it would be improper. They're supposed to post it. The difficulty for you as a contractor is being able to be on top of SAM all the time to pick up on when those sole sources opportunities come up. I was dealing with a big company once that working on, and I had happened to see a sole source award in a particular area of HHS. And it was a large contract, and I was surprised that it was a sole source. And I just happened to ask them about, why was that a sole source? And they said, "What do you mean it was a sole source?" They weren't even aware of it and hadn't picked up on it. The big companies, the people looking at opportunities they're looking where we can bid. They're not necessarily looking, for sole source award. You as a small company, you're kind of more attuned to that. But, so to answer the question, I guess they're supposed to post it. The FAR requires them to post it. The limitation is your ability to see it. And so unless you know that something's coming up that you want to be a part of and you want to monitor, just following SAM is kind of a cumbersome process to pick up on it.
Awesome. Thank you. Can you please define the rule of two for responding to an RFI?
Well, for an RFI, the rule of two doesn't, it's not really, so request for information is that the government, is basically asking a question to the government, the contractor community. So it can be basically anything that the government wants information about. It can be their market research, what veteran company, they won't say veteran, I guess, or what companies, in particularly social class, can bid on this opportunity. And if you get, if say the VA gets back two or more companies so that's where maybe you're referring to the rule two or more companies back that could perform that particular work, then the VA has to set aside that work. But the VA, because you're busy, maybe you didn't respond to the RFI, and the VA didn't get anybody responding as veteran or service-able veteran companies, so they don't set it aside. Your burden to establish that it should have been set aside is more difficult. So if you have the ability to respond to those so that you can fulfill the rule of two requirement, to show the VA that there would be two companies, then I would recommend that you do that.
Thank you. 2 more minutes, everybody. If a company responds to a sole source notice from the VA indicating they have the ability to perform the contract, does the VA have any obligation to respond to the company if they doubt the company's ability to perform the contract?
They don't necessarily have an obligation to respond, but I would say your protest timeline, it wouldn't be 10 days from when you submitted your inquiry. It would be, basically they're leaving it open by not responding to you. So, but you still want to get your protests in quickly, because once they start moving on a sole source award and start performing the work, you don't want to be overcome by events with respect to your protest. So, I would submit the protest, give a reasonable period of time, whether that's 10 days or a little longer, for the government to make a response. And if you don't think there's an appropriate response, I would, at a minimum, file your agency protest and let other decision makers within the agency become involved, because sometimes, other people within the agency will make that decision also. That's not appropriate and shouldn't have been done. So getting that information to other people within the agency could help your cause.
Awesome. Thank you. This is the last question for the day. My understanding is that only the company that was rated second to the winning award would be considered to protest. Otherwise, all others would be denied. Is that true?
Yeah, so for the interested party rule, that's true. So on different types of protests, there might be more than one interested party. So say, for example, the pre-award request, or for brand name products, more than one company could protest that. You could have multiple protesters in that. But it's a post-award if the one awardee and really the only one that has the standing to bring the protest would be the next in line for protest.
Awesome. Thank you. I appreciate you, Mr. Patrick. This has been a wonderful training session. I learned a lot. I hope everybody that was on the call, you appreciate it and learned a lot as well. Please fill out the survey at the end of this presentation. Let us know how we did today. And I hope everybody has a wonderful day. Until next week or next time we see you, everybody stay safe and have a wonderful, wonderful day. Thank you. Thank you.
Thank you very much
for your time. I appreciate you. Thank you. This was great.